Brinsby Stockham, Mr. Lemos and Mr. Friend appear for the respondent commissioners. The court should have been provided with 3 bundles, the core, the supplementary and the authorities bundle.
We have, I will just get it off my chest, we were not supplied with the hard copy of the authorities bundle until late on Friday. In fact, it didn't reach us till Monday, and that is very annoying when you're trying to read ahead and are not electronically literate as some of us are. And I can use an electronic bundle, but I don't find it as easy. Can those behind you please realise that we do need hard copy bundles and we need them 14 days before?
My Lord, yes, my apologies.
Thank you.
On behalf of...
No, I've got it off my chest now, but it is a lesson worth learning. Right, we have them though.
And there were skeleton arguments from both sides, and then a supplementary skeleton that addresses a point that may not arise that we filed.
Yes.
So, proposed to address the court under 6 main headings. Firstly, some brief observations by way of introduction. Secondly, to identify what is common ground and then the narrow issue between the parties. Thirdly, to look briefly at the relevant legislative regimes and the purpose of advanced pricing agreements or APAs. Then to look at what we complain of here about the Commissioner's stance, what's our complaint. Then fifthly, to look at the proper construction of this APA. And then lastly, to look at what we say are the errors of law made by the Upper Tribunal.
Very well. You can take it that we have read the papers carefully and understand what the issue is, which is, in truth, once you get to it, a very narrow issue. And we are hopeful that the full 1.5 days ought not be necessary.
Well, I've had exactly that conversation with my friend Mr. Brinsby Stockham, and we would anticipate, with a fair wind, that we would be done today.
Well, that's very helpful. Annoyingly, I do have to rise promptly at 4:15, in fact, probably at about 4:13. But even so. Okay.
Sorry, may I just ask if we're going to have a transcript?
We are, my Lord, yes, and it can be made available to this court in electronic or paper form or both.
Yes, we haven't had the usual request for permission to take a transcript, but there's no problem. I hereby give it. But I think there is a procedure whereby or if the hand didn't reach me.
I understand, my Lord, that procedure was followed.
I'm wrong then.
Well,
anyway, it's not a problem. If you need permission, I hereby give it. It will be very useful. Yep.
I'm obliged. So, as the court will have seen, this is an appeal relating to an application for judicial review. The public law issues, we believe, are largely, if not wholly, common ground. Mr. Grudzinski will address you on those public law issues to the extent it becomes necessary and helpful to do so. So my first heading, matters of introduction. I anticipate I can take this relatively briefly. But as the court will have seen, there are 4 appellants here. The 4th appellant, TR Corporation, provided an indemnity to the purchaser of the 1st to 3rd. So we're only concerned with the 1st to 3rd appellants, and they are Thomson Reuters UK companies which provided the services in issue. I shall refer to them collectively as TR UK. They are all part of the wider Thomson Reuters group, formed in 2008 from the merger of the Thomson business of Canada and the Reuters business based in the UK. The court will no doubt be aware the TR Group is a large global operator concerned with the provision of data and information to financial services, legal and other sectors. It's headquartered in Canada, but it has operations around the world. Relevantly for this appeal, the TR Group holds a lot of valuable intellectual property, or IP, from which it derives income. That IP is in part held in the United States and in part held in Switzerland. And the company which holds the IP in Switzerland is Thomson Reuters Global Resources, or TRGR. The maintenance and development of that IP requires the provision of various services, and relevantly for the appeal today, some of those services were provided by TR UK to TRGR. The value of that IP depends ultimately on how it can be turned to account, and how much it costs to develop and maintain it, where services are provided by one TR company to TRGR in relation to the IP held by TRGR, the value of those services, which contributes to the value of the IP, might inure over a period of years. Now here, TR UK provided services to TRGR over a number of years, and the value of those services inured to the benefit of TRGR over periods after the years in which the services were provided. Pause there. TRGR pays tax in Switzerland, typically, but not always, at a rate that is lower than the rate of corporation tax in the UK. TR UK pays corporation tax in the UK on profits made here. There is therefore at least a possibility that prices paid by TRGR to TR UK for the services being set so as to maximise profits in Switzerland and minimise profits in the UK. Now, the interests of the revenue are protected in such a case by the transfer pricing rules found in Part 4, the Taxation, International and Other Provisions Act, referred to locally as TIOPA, which requires such intra-group transactions to be priced by reference to the arm's length price in accordance with the OECD guidelines. The determination of what is an arm's length price is, simply stated, notoriously difficult to apply in practice. Businesses and the revenue often find it mutually convenient to enter into an agreement, an advanced pricing agreement, to govern the determination of what is the arm's length price for particular transactions. The idea behind an APA, which I'll come back to, is to agree in advance the pricing of transactions to avoid a fight later that looks back to the past. The current appeal relates to an APA entered into by TR and the revenue in 2013, and specifically we're concerned with the proper construction of that APA, where the revenue seek now to impose a charge to Diverted Profits Tax. Now, the background has some complexity to it, and the specific legislative regimes may not be familiar to this court, so there is a stiff climb to the battlefield. Once we are there, it is indeed a short point. So, second of my headings, what's common ground? It's common ground between the parties that the APA is a binding contract between TR and the revenue to be given effect to in accordance with its terms, purposively and contextually construed. It's also common ground that the relevant DPT notices will be unlawful in a public law sense to the extent that they are inconsistent with the APA properly construed. Thirdly, it's common ground that the transfer pricing rules are designed to identify and give corporation tax effect to the arm's length price for transactions between here connected group companies. Fourthly, the DPT rules are designed to impose a separate tax, Diverted Profits Tax, in relation to profits which have been inappropriately diverted away from the UK and put outside the scope of UK corporation tax. Now, in certain circumstances, the DPT charge operates by reference to the arm's length provision, and indeed the arm's length price of the relevant transaction. And that arises where in the language of the DPT code, the relevant alternative provision, or the RAP, is the same as the actual provision. I'll come back to both of those in a few moments, such that the corporation tax and the DPT regimes operate by reference to the same arm's length price. Now, I'll show you this in a little while, but the DPT code contemplates two worlds. Firstly, where the relevant alternative provision that the revenue think ought to have been entered into is different to the actual provision. Second possibility is the relevant alternative provision is the same as the actual provision. In that latter case, you're only concerned with the pricing of the actual transaction. In this case, it is agreed falls into the second category. So we are only concerned for DPT purposes with the arm's length price of the relevant transactions. Now, the revenue originally took the point that corporation tax and DPT are different taxes, but they rightly recognised before the hearing in the Upper Tribunal that this is not necessarily an answer to reliance on the APA, since in some cases an APA agreed for the purposes of corporation tax could be effective to prevent a DPT charge. So the different tax point is accepted not to be a good answer to TR's complaints here. It's also agreed between the parties that the APA here has effect to determine the appropriate transfer pricing method for pricing the provision of services by TR UK to TRGR in relation to the IP that's held by TRGR in Switzerland. We'll see those services identified when we get to the AP in a little while. They're defined as the covered transactions. It's also agreed that the APA has a particular term and duration running from October 2008 to December 2014. It is also beyond argument that the DPT notice that is challenged here by this application relates to the accounting period of the TR UK companies for 2018. And it is that fact, the revenue say, and the Upper Tribunal accepted, that is said to be the answer to TR UK's challenge here. Revenue accept they can't make the different tax point, but they do make the different year point. And it was that point that was in effect accepted by the tribunal below. And so this is ultimately the narrow question for this court. Did the Upper Tribunal err in law in accepting from the commissioners that because the APA has a term running from 2008 to 2014, it can have no effect as regards a charge to DPT in 2018? And we say yes, that is an error of law, and the commissioners say no, it's not. So it is ultimately, as my lord observed, a short question of contractual and statutory construction. In particular, what is the proper construction here of this APA, and what is the proper construction here of the term relates to in section 220 of TOPA. And if we're right about the construction of the APA, then we say 2018 is a year to which it relates. If we're not right about the construction of the APA, then we are likely not right about whether it is a year to which the APA relates. Just for your note, it may only be a footnote, the revenue raised a viries point, which would only be operative if this court were to conclude that we're right about the APA, that 2018 is not a year to which the APA relates. And in that world, the revenue skeleton raises the point, well, maybe they didn't have viries to enter into that agreement at all.
That's the fired point.
That's the viries point.
That's based on the Alfired case.
Yes. Not a point raised in a respondent's notice. We've put in a short skeleton by way of an answer to it. Mr. Krasinski will address you on that if it becomes material, but it only arises where you've taken one view about the construction of the APA.
Well, let's just, you say if it becomes material, but unless we tell you beforehand what we say we're going to say, it will be potentially material.
Well, yes.
So he will address us, unless we're very bold.
Unless you formed a view before we get to that point.
Yes, right. Thank you.
So that's the viries point, that's how it arises, and you have the materials in the authorities bundle to allow Mr. Krasinski to address that. Third of my headings, the legislative regimes and the purpose of APAs. Now, the TR UK companies are UK resident and they're liable to corporation tax on their profits, computed by reference to accounting periods. And you can get that out of sections 2 and 8 of the Corporation Tax Act 2009, which is in the authorities bundle at tab 2, page 6. There's no dispute between the parties about that, so I'm not sure I need to turn them up. But the proposition is if you're a UK company, you're liable to corporation tax on your profits.
And I take it there's no dispute that a corporation tax, if it is relevant, it is an annual tax, which has to be reimposed every year in the same way as income tax.
Yes. Yes. The rate is set each year by reference to a financial year, but my lord is right. Has to be set each year. Now, to guard against manipulation of prices and thus profits between connected persons, the legislative code makes provision for transfer pricing rules to require the computation of profits by reference to the arm's length price. And that's found in part 4 of TIOPA. And it would be helpful if the court could turn this up. It's in the 3rd tab of the authorities volume. Beginning at page 10. This is part 4 of TIOPA headed transfer pricing. And what you have here is chapter 1, basic transfer pricing rule. Section 146 provides that these rules apply for the purposes of corporation tax and income tax, the former we're interested in. And then section 147 provides that the basic precondition is that A, the provision, the actual provision, has been made or imposed between any two persons by means of a transaction or a series of transactions. You've got transactions between two persons. The participation condition is met. Well, we'll see that in a moment, but in effect you've got a connection between the two companies. C, the actual provision is not within subsection 7, so it's not oil related. And then D, the actual provision differs from the provision, the arm's length provision, which would have been made as between independent enterprises. So in those circumstances, subsection 2 provides, subsection 3 applies if the basic precondition is met and the actual provision confers a potential advantage in relation to UK taxation on one of the affected persons. So what you're looking for is some UK potential advantage, and then subsection 3 provides the profits and losses of the potentially advantaged person are to be calculated for tax purposes as if the arm's length provision had been made or imposed instead of the actual. Section 148 explains the participation condition. Perhaps the court will take it from me. What you're looking for is one company controlling another or both being controlled by a third party. As a simple example. You're testing the relevant connection between your two parties. And then over the page, page 13, section 150 tells you what is meant by transaction and series of transactions. It is almost any form of interaction between one company and another, one can see from subsection 1. And then page 14, section 151, explains the arm's length provision. And then subsection 2 of 151, for the purposes of this part, the cases in which provision made or imposed as between any two persons is to be taken to differ from the provision that would have been made as between independent enterprises include the case in which provision is made or imposed as between two persons, but no provision would have been made. That's telling you you're either looking at pricing the transaction they entered into, or you might also be addressing a world in which they wouldn't have entered into the transaction at arm's length. And then turning on to page 18 in the bundle, section 155 identifies what is meant by a potential advantage in relation to UK taxation. Subsection 2 provides the actual provision confers a potential advantage on a person in relation to UK taxation wherever, disregarding this part, the effect of making or imposing the actual provision instead of the arm's length provision would be one or both of effects A and B. And effect A, you have a smaller amount of profit. And effect B is that you have a greater amount of loss. So either of those can be your potential UK advantage. And you look at effect A and effect B by reference to relevant chargeable periods. Well, you don't have this in the bundle. Chargeable period is defined in the Corporation Tax Act 2010 for companies as being a reference to accounting periods. So just pausing there, the transfer pricing regime identifies transactions between connected persons and asks, have these been appropriately priced in the simple case where you're not postulating that they wouldn't have entered into the transaction at all. What we are directed to identify is the arm's length price, where that differs from the actual price that was charged by one company to another. Now, provision is also made in TIOPA. Here it's the same tab, but one turns on to page 77 to part 5 for advanced pricing agreements. So section 218, meaning of advanced pricing agreement, means a written agreement made by the commissioners with any person A as a consequence of an application by A, and it relates to one or more of the matters mentioned in subsection 2. And then subsection 2 identifies matters that can be the subject of an advanced pricing agreement, and here we're concerned with little e, the treatment for tax purposes of any provision made or imposed, whether before or after the date of the agreement, as between A and any associate. And then section 219 defines an associate, in effect by reference to the participation condition. So if you're a controlled company, then you are associates, and therefore you can seek to treat the provisions between you as subject matters of the APA. And then section 220, page 79, the effect of an agreement on a party to it, subsection 2 applies if a chargeable period is one to which an advanced pricing agreement relates. So there's that reference to relates. And then subsection 2, the tax acts have effect in relation to the chargeable period, as if in the case of the person with whom the commissioners made the agreement, questions relating to the matters mentioned in section 218 sub 2 are to be determined in accordance with the agreement and without reference to provisions in accordance with which they would otherwise be determined. So you look to the agreement and not what would otherwise have been the provision. Sub 3 provides that sub 2 is subject to subsections 4 and 5 and section 221. Subsection 4, a question is to be determined as mentioned in subsection 2 only so far as the agreement provides for the question to be determined in that way. So you look to the scope of the agreement and that determines the effect of the agreement. And then subsection 5, in the case of so much of a question as A relates to any matter mentioned in paragraph E or F of section 218.2 and is not comprising a question that relates to a matter within another paragraph, reference to a provision is capable of being excluded under subsection 2 by an advanced pricing agreement only if the provision is in part 4. So if you're in section 218 2E, then the effect of the agreement is limited to the transfer pricing rules in Part 4. So here that tells us that if the APA applies, to the extent that there is a transaction, a covered transaction in the APA, then the terms of the APA are to be applied to the exclusion of the transfer pricing rules that would otherwise have applied. Section 223 makes provision for an application to be made for an APA. Section 224, page 81, might be relevant, and that allows an agreement to deal with years ended or begun before the agreement is made. Now, the court will have identified here this agreement was made in 2013, signed in 2013, but it had effect for 2010 through to 2014, and it also had effect for what is described as a rollback period that went back to the 1st of October 2008. And the vires for that is to be found in section 224.
Section
224.
Oh, I see, yes.
Now, the only temporal limit on that is subsection 2. You can't roll back before the 27th of July 1999 because that was the date upon which these provisions were first introduced.
And sorry, this is just to satisfy my curiosity. Why did the period from October 2008 to 2009 have to be dealt with as identified as a separate rollback period, as opposed to the period from 2010 up to the signature of the agreement in 2013?
Yes. I confess I've also wondered why one is described as a rollback and the other isn't. My understanding is that the application had been made
I thought
in
that must
relation
be the
to
reason.
2010
Yeah.
onwards.
Yeah, there must be something here that says once you've made the application, the fact that maybe the agreement may not be signed for ages doesn't matter. That's regarded as within the scope of the application, whereas the rollback is, yeah, okay,
And
that's fine.
I can't quite find that in the statutory code, but
It must be something like that.
that makes logical sense.
Sorry, that's just me wasting time, but it puzzled me.
Section 225, page 82, allows for the modification and revocation of agreement. The commissioners have the ability to modify or revoke the agreement. 226, they can annul the agreement if they think there's been misrepresentation. Over the page 227, you can be penalised for misrepresenting matters in an APA. And then 228 requires the provision of information.
Do we need all these?
Well, there is one point. There was an obligation to provide an annual report as to compliance with the agreement, which we did. But the justification for that is section 228. I'll come back to that in due course. So, what then is the purpose of APAs? Well, that is very helpfully set out by the revenue themselves in a statement of practice that's in the supplementary bundle for this appeal at tab 2. So that's page 18 of the bundle, and it's statement of practice 2 of 2010. This is a version that had been updated to July 2019, but nothing's going to turn on that. Can I invite the court to start with page 20?
So sorry, I got the wrong button. A second. Yes.
So, page 20, heading General Introduction. HMRC has run an advanced pricing agreement program since 1999 to assist businesses in determining the most appropriate methodology to derive the arm's length outcome for complex transfer pricing issues and prevent disputes arising that may otherwise result in a mutual agreement procedure being necessary later. That's a reference to a way of resolving transfer pricing disputes across borders. And then there's a couple of paragraphs explaining what this statement of practice is about. Then between the two hole punches, what APAs are and when businesses might consider one. An APA is a written agreement between a business and the commissioners of HMRC which determines a method for resolving transfer pricing issues in advance of a return being made. When the terms of the agreement are complied with, it provides assurance to the business that the treatment of those transfer pricing issues will be accepted by the revenue for the period covered by the agreement. So, assurance for the period covered by the agreement. 2, the revenue has found that where there is considerable difficulty or doubt in determining the method by which the arm's length principle should be applied, the transfer pricing issues can be more efficiently dealt with in real time as they arise, rather than retrospectively years later, when, for example, key personnel in the business may have moved on. And then 3 harks back to what Section 218 can cover. 4, foot of the page, the potential scope of an APA is flexible. It may relate to all transfer pricing issues or just some of them. Can apply to pre-existing issues. And then there's an explanation which we're not interested in about the difference between a unilateral, a bilateral and a multilateral agreement. That's over the page. And then at the foot of page 23, there's a heading, Term of the Agreement and Rollback. But looking at that at the top of page 24, an APA, paragraph 25, an APA will be operative for a specified time from the date of entry into force as set out in the agreement. The business should propose a term for the APA, taking into account the period over which it is reasonable to assume that the method for dealing with the relevant transfer pricing issues will remain appropriate. Typically, the term is from 3 to 5 years, and a longer term will only be considered in exceptional circumstances. And then 26, it's possible that a chargeable period to which the APA relates may have ended before agreement is reached. Section 224 allows the APA to be effective. And then 28, the agreed transfer pricing methodology may be relevant for an earlier period and to the resolution of any transfer pricing inquiries raised for earlier periods, if the particular facts and circumstances surrounding those years are substantially the same. So those references make clear that one of the key purposes of an APA is to provide assurance and certainty to businesses and to the revenue, to allow difficult questions of transfer pricing to be addressed in real time by reference to contemporaneous evidence, where it is envisaged that such agreements will remain in place for as long as the original basis for the agreement remains true.
Would you also accept that one of the underlying legal purposes of this legislation is also to get round the problem the revenue would otherwise face about binding itself in relation to future periods, when it's quite a big and difficult question as to how far, if at all, that may legitimately be done in the context particularly of an annual tax, where no issue of stopple arises between years?
There was before, and there is after the decision in Al-Fayed, an open question as to the ability of the revenue to enter into this sort of agreement.
Yeah.
Now, in Al-Fayed, it was an extreme example because the revenue promised Mr. Al-Fayed that they would take a flat sum, irrespective of his taxable income, for years going forward. And the court said, I'll paraphrase, no, you don't have the power to do that. But whether, absent this legislation, the revenue would not have had the power to enter into an agreement by which they agreed methods to determine transfer pricing questions is not necessarily answered by the decision in Al-Fayed. They're different beasts.
Yeah.
Now, that point doesn't arise because this code was introduced in 1999 to give specific diaries to the revenue to enter into APAs.
That sounds like is this a summary of your position? There might have been arguments about whether such arrangements were caught by the ratio of Al-Fayed, but this puts any arguments beyond doubt. And therefore, that if that is so, what my lord put to you as part of the purpose would be correct. Have I misunderstood?
No, I must accept that that is part of the purpose.
I mean, understandably, the revenues practice looks at the matter from a practical on the ground perspective of companies, whereas from a lawyer's perspective, one's also worried about or at least one might be worried about the varies point, which is dealt with at the same time by making it clear beyond argument that the revenue does have power to bind itself up to 5 years in the future.
Yes.
Or up to whatever the term of the APA may be.
Now, if the 5Es issue is going to be a live one here, I shouldn't trespass on Mr. Brzezinski's ground and leave him to deal with that. But my Lord is quite right to observe that this gives statutory authority to the commissioners to enter into a contract, where that contract is designed to agree methods for years after the date of the contract.
I couldn't find that at all in the statute. Am I missing something that says in terms HMRC can agree future years that haven't even begun at the date of the contract? But I do see it in the guidance that that's the 3 to 5 years.
It is the effect, my lady, of section 224, which
I'm looking at that. I mean, I can't see that. That 224 talks about chargeable periods beginning or ending before the agreement is made. Am I missing something, or am I missing something that says that you can do future, you can relate it to future chargeable periods?
224 is giving specific authority for looking back.
Yeah.
It's a combination, in effect, my lady, of section 218 and 220.
Yes.
Because they are identified as pricing agreements that are advance, and 220 envisages that once you've determined whether a chargeable period is one to which the agreement relates, then the tax acts have effect for that chargeable period as if.
Yeah.
Yes, so inherent in the concept of an advance agreement, I suppose.
Yes.
Yeah.
Yes, the word advance is really.
Well, and my friend rightly observes 2182E, the treatment for tax purposes of any provision made or imposed, whether before or after the date of the agreement.
So it's really implicit in the statute, but explicit in the guidance. Is that
Well, yeah,
2182E doesn't quite meet the point, but it must be, as you said, the whole, as my Lord and you both, the whole concept of an advance payment. It doesn't say it's limited to a current tax year.
No.
Or to a transaction that's already, and clearly isn't related to a provision with taking effect in the past. So
a combination of 2182E, 220 and 224, and the very thing itself, the advanced pricing agreement, would suggest that Parliament envisaged that it would have effect for future periods.
And that point is sharpened if one thinks about the alternative. If we didn't have this legislation in place, one would have all these arguments about issue estoppels between subsequent years and so forth. Well,
and you would have the very real possibility we face in this case, that we will eventually get to the first tier tribunal to fight these underlying issues in 2025, or even 2026, we don't know. But what we'll then be arguing about is what's the right transfer pricing result for 2018, but we are then looking back to services that were provided in 2008. So all of the practical difficulties that this sort of agreement were designed to avoid would arise. I'll come back to that. Now, in case it's helpful, in the authorities bundle, there are some OECD guidelines about advanced pricing agreements. They're at tab 31, page 887. And this sort of advanced pricing agreement is not peculiar to the UK. Lots of jurisdictions around the world have them. Not all, but many. And the OECD produce guidance in their guidelines. This is chapter Roman 4, page 885, administrative approaches to avoiding and resolving transfer pricing disputes. And then at 887, there's a section about advanced pricing agreements. don't propose to read it to the court now, but perhaps if I invite the court just to note and perhaps come back to paragraph 4.134 explains the concept of an APA, and then the rest of that section is worthy of some consideration. And then over a couple of pages to 892, paragraph F3, there's a section on the advantages of advanced pricing agreements. Now, I quite recognise that the next section, F4, is headed disadvantages relating to advanced pricing agreements, so there's a balance to be struck. But one gets the strong flavour of the purpose of an APA from 4.153. An APA programme can assist taxpayers by eliminating uncertainty through enhancing the predictability of tax treatment in international transactions. And then the first sentence of 14154, APAs can provide an opportunity for both tax administrations and taxpayers to consult and cooperate in a non-adversarial spirit and environment. And the first sentence of 155, an APA may prevent costly and time-consuming examinations and litigation of major transfer pricing issues for taxpayers and tax administrations. So all of those relatively self-evident advantages of an APA were what no doubt motivated the UK to adopt such a regime in Part 5 of TIOPA and sit as purposes underneath this particular APA. So the last bit of the legislative code that you need to see, and this is, I'm afraid, a tougher read, the DPT regime. In the authorities bundle at tab 4, this is the Finance Act 2015, Part 3, and that imposes a diverted profits tax. Section 77 is the introduction to the tax. 77.
So tell me where we're going?
Sorry, well, it's page 86 at tab 4 of the authorities bundle.
Just give us a moment. I've posed my lord a case management test. You can deal with it later. When you get boring, this bit sounds interesting.
Nobody, I think, has ever said that about DPT. Maybe never will. The court really only needs a sort of an overview. I don't want to get too bogged down in the detail because the detail is not an issue between us. But there is a new tax, 2015 Diverted Profits Tax, subsection 2 of 77. It will arise, so taxable diverted profits arise, if one or more of sections 80, 81 and 86 applies. And then section 78 says sections 80 and 81 relate to cases involving entities or transactions which lack economic substance. And again, at a very high level of generality, DPT looks for two circumstances. Either you've got a UK company that is engaged in transactions with a non-UK company where the transaction or the entity lacks economic substance. And in those circumstances, you might be able to divert profits away from the UK. Second circumstance is where you've got a non-UK business that does business neutrally with the UK, but manages to avoid having a permanent establishment in the UK. So either of those would be circumstances in which you might divert profits away from the UK. Either you're paying sums away to a related entity, thereby reducing your UK profit, or you're structuring your affairs so you don't bring profit into the UK at all. Now, it is said here against us that we're in the category of a UK company, so the TR UK companies, that are engaged in transactions with non-residents, here TRGR. It is said against us that we're diverting profits by the terms upon which TR UK deals with TRGR. So we're a section 80 or 81 case and not a section 86 case. And the charge to tax is identified in section 79, and it's a flat 25% amount of your taxable diverted profits. 79 sub 2. So the court will perhaps appreciate the rate of corporation tax has in the past been lower than 25, and DPT was set at 25. So it's 25%, and then page 88, section 80, a UK company, involvement of entities or transactions lacking economic substance, and the section applies if you've got a UK resident company, provision has been made as between C and another person. Little c, the participation condition is met, so they're related. And then over the page, little d, the material provision results in an effective tax mismatch outcome. Again, in broad terms, the rate of tax, the amount of tax that is collected is less than it otherwise might have been. And then little f, the insufficient economic substance condition is met. So it is said against us that those requirements are met, and if that's right, then we would be liable to DPT, but in determining the amount and the basis for the charge for DPT, you have to work out whether we're a case in which the relevant alternative provision is different to the actual provision. That's provided for in section 82. 82.4 requires the identification of the material provision. Section 82.5 requires the identification of the relevant alternative provision for the RAP. Now, this is agreed between the parties. We are a case in which the RAP, the relevant alternative provision, is accepted to be the same as the actual provision. The actual provision is the IP is held by TRGR in Switzerland, and TR UK companies provide services to TRGR in return for fees. So that's both the actual provision and the relevant alternative provision, so there's no difference between the two. So we are then only concerned with the question as to whether the actual prices paid for those services are at arm's length. And if they're not at arm's length, then in effect the TR UK companies are taxable on the excess, the difference. If they are at arm's length, there's no charge to DPT. So it's that which allows the revenue to accept, in this case, that because we're concerned with the same arm's length price question, the APA that is designed to answer that question for corporation tax purposes can also have effect for DPT purposes because you are asking the same question. So originally, before we got to the hearing in the Upper Tribunal, Revenue took the point, well, DPT is a different tax to corporation tax. The APA only deals with corporation tax, therefore it could never be effective for DPT purposes. But the Revenue recognised, before we got to the hearing, rightly, that there are some circumstances in which you're asking in effect the same question. And if the APA provides for an agreed method to determine the arm's length price, and that APA is effective both for corporation tax purposes and here for DPT purposes. And that's now the subject of public expression by the Revenue. It's in their manual. It's in the authorities bundle at tab 29, in particular at pages 874 and 876. That's a long-winded explanation as to why the different taxes point fell away. It won't always fall away, but it's agreed that it falls away in this case. fact that the charge to DPT that we complain about in 2018 is a charge to DPT and not corporation tax is not an answer. So my fourth main heading, what's our real complaint here with what the commissioners are trying to do by their DPT notices in 2018? As we'll see in a moment, the parties agreed in this APA on an arm's length provision for particular services provided by the UK companies to TRGR in Switzerland on a cost plus basis. In the jargon of transfer pricing, it's like, or it's a species of transactional net margin method. But for practical purposes, this court can think of it as just being cost plus. So if the services were provided on a cost plus, say, 10% basis, if TRUK's costs were 100, they were assumed for purposes of UK tax to have received 110, so they were guaranteed to make the 10% by way of profit. As we'll see again in a moment, the APA does not seek to agree specific prices for services in pound terms, nor does it seek to agree specific profits in pound terms. Instead, it seeks to agree specific methods by which the arm's length price can be arrived at for particular services. And for the services we're concerned with, the parties agreed a cost plus a percentage. They did not agree cost plus, say, 10%, plus some other share of any future profit made by TRGR. The parties could have agreed a cost plus percent and a kicker, or an overage, based on future events, but they didn't.
How could they have done that if this has to have sufficient certainty? You could only know what happened in a given year, or at a max what happened in the course of the agreement. You just don't know what might happen.
Well, parties could have provided, in the event that the IP for which you are providing services is sold, we will attribute a proportion of any gain made on the sale of that IP as an additional reward for these services.
That would have incorporated into the APA. I mean, it may be that you could have done that, but the mechanism would have been a retrospective adjustment, because in the year in hand, you wouldn't have had any profit share. 5 years later, let's say, you might have then thought, oh, we need to adjust what we paid in 2014.
Well, that would be the case, but you could agree a method, because this is about agreeing methods, not agreeing numerical specifics.
That may be right, that it is possible to reduce to a methodology what you are describing. It is possible to do that, but the issue, I suppose, is whether that's really what the APA is getting at.
Well, not only is it possible, the parties did that for services that we're not concerned with.
Okay.
I'll show you that when we get to that. They agreed a profit split method. But they didn't agree a profit split method for the services this appeal is concerned with, nor did they agree any kicker or overage. So there's no cost plus plus, there's no profit share method for these services. Instead, the parties agreed particular methods for particular services over that 7-year period between 2008 and 2014. So if the costs were always 100 in each year, TRUK was treated as receiving 110, it made 10 each year and 70 in total. The revenue then say, let's imagine in 2015, that cost plus is not the right method to price these services. Instead, the revenue say, well, we think it ought to be a profit share method. So we'll look to the profit that TRGR made in 2015 onwards and attribute a share to TRUK as an additional reward for the services provided. Now, in principle, the revenue can do that. they can change their mind about the appropriate method of arriving at an arm's length price for 2015 to 2018. We don't say otherwise.
They couldn't do it, I think you'd say, for 2008 to 2014.
Yeah, we do say that.
That's the hard edge.
That's
they
the hard
couldn't do that if it was within the stated period of the APA.
Yes.
But you, okay?
I'm going to progress in stages, and there may well be noddy stages, but
No, let's do noddy, that's good.
the court will indulge me for a moment.
And equally, I mean, the revenue have not sought to reopen the 2008 to 2014 periods.
Nope.
No.
We say that's
You say that's
true
but irrelevant.
true but no answer.
Yes.
Now, we say the profit split method's not the right method, and we say their proposed profit split method is wrong and it's wrongly implemented, but they're all matters for the first-tier tribunal when we eventually get there. But the problem arises because the revenue say, let's say for 2015 through to 2018, that the profits made by TRGR in those periods reflect in part the services provided to them in 2008 to 14 as the benefit of the services in yours going forwards. And so they say, well, TRGR made a profit, let's say in 2015, but part of that profit is really attributable to the services that were provided in 2008 and 9 and so on through to 14. So the revenue say in consequence that for the purposes of attributing the profit share to TR UK, from the profits made by TRGR in 2015 to 18, the services provided in 2008 to 14 should be priced on a cost plus basis, plus a share of the profits that TRGR made in those later years.
So going back to your earlier submission, you said in principle we were looking at 2018 to 2014 as the first period, and then you said in principle HMRC can change its basis to a profit share basis in year 2015.
Yes.
In principle.
In principle.
But your case is that principle has to be caveated because HMRC can't do that if there's any part of the profits in 2015 which might be or is attributable to profits 2008 to 2014.
To services in 2000.
So it would have to be, let's call it new profits only.
It has to be attributable to new services, new profits, but new services, post-APA services. So, in effect, we say the revenue want to price differently, we say reprice, the TR UK services that were provided in 2008 to 14, despite having agreed an arm's length price for those services in the APA. And we say that offends the APA. Now there's one other highly material feature. The revenue want to apply their new profit split method to the regular ongoing profits made by TRGR in 2015 to 18 by allocating an additional return to TR UK for the services provided in 08 to 14. Now, the figures, the mathematical consequence of that is still to be argued about, but it's likely to make a relatively small difference to TR UK's tax position. And the court may have identified that this judicial review does not extend to the repricing of TR UK's 2008 to 14 services by reference to an allocated share of TRGR's ongoing profits in 15 to 18.
15 to 17.
Ongoing profits in 15 to 18.
I must have misunderstood your point then. You just make it again.
Well, TRGR made ongoing regular profits, revenue profits, if you like, income profits, in 15, 16, 17 and 18. And if the revenue are right, they take a slice of that profit and attribute it back to the services provided in 08 to 14.
Is that, I thought that I thought that the attribution exercise was only necessary in 2018 because it arose out of the sale of the rights. If you're just talking about regular profits in 2015 to 2017, such an attribution exercise is not necessary. Have I got that wrong?
Well, that is wrong. On the revenues view of the world, they apply a profit split in 15, 16, 17.
Yeah, that I get.
And as part of that profit split exercise, they want to allocate profits of 15, 16, 17 back to the 2008 to 14.
How do we know they want to do that?
That's in their profit split model. It's common ground.
Are you saying you're not challenging that?
Well, the judicial review that we brought didn't challenge that, although logically we should.
Logically it should, shouldn't it?
Logically,
the same point would apply. You're either right or you're wrong.
yes, either we're right or we're wrong, and logically we should have done, but we didn't, because it makes, numerically, we think not much.
So you're going for the big money in 2018.
But in 2018, there was regular ongoing profits and the sale of the IP as part of the transaction with the London Stock Exchange, where the revenue say, in that year, both the regular ongoing profits in 2018 and a large gain that they say TRGR made should both be put into the profit split model. And both of those elements contribute to an attribution of a part of the profit that TRGR made back to the 2008 to 14 services in order to determine the profits of TRUK. So the revenues say the Swiss company made a huge gain, that's disputed. The revenues say that huge gain should be run through the revenues profit split model, and that's disputed. But they then say, well, the result of that is that the services provided by the UK companies in 2008 to 14 should have allocated to them both a share of TRGR's ongoing profits in 18 and also a share of that large gain. And that makes a significant financial mathematical difference to the charge to tax in TRUK. So what the revenues profit split model does, and this is all common ground, this is what they're trying to do, is to attribute a slice of the gain made on the sale of the IP as an additional reward for the services that were provided in 2008 to 14. So our principled objection, it's our real beef here, is we say they can't reprice the services provided in 2008 to 14 because the appropriate transfer pricing method has been agreed for those services on a cost plus basis and not a profit share basis, nor even a cost plus plus basis. So what the commissioners are trying to do here is to go back on to negate, to undermine the contract they agreed, for good reason, with TRUK for 2008 to 14. That APA, like all APAs, was designed to bring certainty of treatment for transfer pricing purposes to particular transactions for the benefit of taxpayers and for the revenue. And it is specifically designed to prevent repricing up or down by either party at some later juncture. And we say a deal is a deal. Neither side can say later, well, we wish we had applied some different TP method to different effect, or we should proceed as if we had done that, we didn't. And our answer is both sides should be held to the deal they've done, and that's how APAs are designed to work. And indeed, APAs are specifically designed to avoid exactly this scenario, the parties having to argue in 2025 or 2026 about the appropriate arm's length price for transactions that were entered into in 2008 through to 14. So the revenue stance here negates the very purpose of APAs. So if we're right about that basic complaint, then the DPT notice for 2018 is a year to which the APA relates, such that the APA has effect so as to override the statutory provisions, and the commissioners are not permitted, in effect, to reprice services provided in 2008 to 14 and thereby override the APA. Indeed, had the revenue made their current point at the time of the agreement of the APA, if they'd said, well, we're agreed the services are cost plus 10%, but we reserve the right to reprice these services in a later year if we think a profit split method would be appropriate, then the APA would not have been signed in its current form. It may not have been signed at all.
Well, you assert that. It might be true, it might not be true.
But no well-advised group of companies operating cross-border with some operations in the UK will agree advance pricing agreements with the revenue going forward if the revenue are able to go back and reprice that which has been agreed through the application of a different method later.
When you say that, why they might think this is a very good deal for the next 5 years. We'll probably be able to renew it, or we may not after the end of the next 5 years. If it arises, it may never arise in subsequent years.
Well, it's not about is it a good deal we might be able to renew. The stance of the commissioners here is, yes, it was let's assume it's a 5-year term, it's a 5-year deal, but we, the revenue, can decide later that we should have thought of a different transfer pricing method, and we can apply that method in.
But that's only in respect of your tax liabilities in future years, at the end of the period, after the end of the period. So it is a different deal.
My lord, that is the question in the.
Well, I know it is, but that's your rhetorical point. No one would have entered into this. I have no idea economically, or I'm not a tax advisor. Maybe they would, maybe they wouldn't. There's not a logical absurdity in making a deal about the method for your tax liability in 5 years, which doesn't extend to your liability for years thereafter.
Well, that's one way of looking at what's going on here. But if that further later consideration of the transfer pricing method involves allocating profits to a UK company for services that were provided in the period covered by the APA, then a taxpayer is going to say, well, that doesn't really give me any certainty.
But it gives you certainty in respect of your liability for the following 5 years, or as it actually happens, the last 3 years and the next 2 years. But that's the point.
But my lord, let's just pursue this for a second. If your lordship were right, well, it gives me certainty as to my taxable profits in the UK for years 1 to 5.
Yeah.
But in year 6, the revenue can say, well, we're going to reprice the services provided in years 1 to 5, and we'll claw back any advantage you might have got in year 6. Claw back in year 6 any advantage you might have got in years 1 to 5.
What I haven't quite understood, I suppose this is quite may or may not be a basic point. Is there a certainty that in years 6 to 10, there will in fact be any occasion to reprice services for the previous 5 years? You wouldn't normally be taxing.
Well, your lordship has put a finger on another important point. It's only because here it's the happenstance of the sale of the IP that gives rise to the big gain in 2018 that causes our complaint. But the revenue could only do what they're purporting to do if we'd continued to provide services after 2015 through to 2018.
But those are fresh services.
Yes, but absent those fresh services, the revenue, there'd be no basis on which to seek to apply a profit split method to attribute profit back to the UK.
Let's suppose you've never sold the IP, ever. in what circumstances would you be taxing in years 5 to 10 for services, or for the price of services, or I should more accurately say profit made from the provision of services in years 1 to 5?
It comes because the revenue have applied a profit split method. So if they'd moved from cost plus 10 to cost plus 20, it's easier to see that in years 6 to 10 there's no need to refer back to years 1 to 5. But because they've applied a profit split method, what they want to do is to allocate profit to the UK companies.
Well, perhaps you better spell out to me what conceptually what a profit split method involves.
What the revenue do is to say the Swiss company TRGR made a profit from the exploitation of its IP. And let's just call that profit in a given year of 100. But they say, the revenue say, the value of the IP and the ability to generate profits of 100 from it is the product, in part, of the development and maintenance services provided by other group companies.
Yes, but why isn't that done on a year-by-year basis? So the profit that TRGR make in year 6 is based on the supply of services in year 6.
That would be one way of applying a profit split method. But what the revenue seem to do is to say, well, the profit in year 6 is generated by the services of year 6, but it's also generated in part by the services of years 1 to 5, because the value or the benefit of those services inures for more than 1 year.
Just so it's not wholly abstract, what sorts of services are these?
Well, there's a list in the APA, but they are some very basic maintenance type services, and then there are some IP development services. So it's perhaps easier to see in the development of IP, because if you're contributing to the development of IP, that will have a value that will erode. If you do nothing else, it'll erode over time, while the value of your IP has an economic life. So what the revenue say is, well, profit split in year 6 requires us to allocate profits to the service providers to reward their services in year 6 and in years 5, 4, 3, 2, 1.
But to be very, just to take a boring legal example, suppose we were talking about legal IP generation of legal textbooks. You're saying you supply the IP consisting of the copyright in a legal textbook, which has a shelf life of 3 or 4 years. You do that in year 1, but the profits that are made from that go on in year 3. The profits go on into year 7, at which point there's a new edition of the legal textbook and it becomes worthless. That's the sort of thing we're talking about.
Yes, the value of your IP, let's assume it's got a shelf life in a legal textbook of maybe 5 or 7 years. It falls over time, but when you realise a profit from exploiting the copyright in that legal textbook in year 7, the revenue's thesis is that is in part the product of services that were provided in year 1. Or updates in years 2, 3, 4, and 5. But they're not seeking...
Well, updates is a confusion, but yes.
But they're not seeking to apply profits by reference to services of year 6. If they were doing that, we would have no complaint.
No, quite. No, I understand. It's about the services.
So they say we made a big gain in 2018, billions of dollars. Some part of that $1 billion gain should be seen as an extra reward for the services that were provided by these UK companies between 2008 and 14. And so it's because it is a profit split method, and because they apply their method on the thesis of the value inuring over a number of years, services.
Yes, it's that feature rather than the fact of it being a profit split method as such.
Yes. It's the combination of the two. And they say, well, you, the UK companies, were rewarded, let's say cost plus 10, but now we know what it was sold for in 2018. We think you ought to have had cost plus 10 plus X, where X is a share of the realisation value of the IP, because you, the UK companies, contributed to that value by the services you provided in 08 to 14.
So isn't it looking at slightly different things, just conceptually? So when you start on a year-by-year basis in 2008 to 2014, you're looking, roughly speaking, at what might be the arm's length value of the services looked at on an individualised basis, so development, maintenance, those sorts of things. What would arm's length companies charge from one to t'other for providing those services? And you carry along like that. But what happens in 2018 is that the whole of the IP gets sold, I think, to a joint venture, so it's, anyway, it doesn't matter.
It's a joint venture and then ultimately bought out.
And then you say, well, hold on, this is the whole package getting disposed of. So we're looking at something a bit different. It's not an itemised, bit-by-bit approach. You're looking at the whole package and saying, what really was that worth? Some being worth more than the parts and all of that approach. So you come up with your figure and then you say, well, actually, where does that profit, how does it get split out, or where does it fall, or who, you know,
Who contributed to...
do you distribute it?
Yeah, who contributed to the making of that profit?
Yeah. So it's sort of slightly different things you're looking at, isn't it, in these two periods,
But look,
two sets of periods.
what the commissioners want to do is to say, yes, you made that gain, let's see who contributed to the value of the IP that you sold.
As you're explaining that position, although it arises in a different way from the ordinary annual profits from the exploitation of the IP and from the sale of the IP, the Commissioner's position is objectionable in principle in either kind of case, because in both kinds of case it involves treating the profit, whether made from the sale or from the rent, the fees they charge for use of their IP, by reference to, in part, to services provided in the previous year.
Yes.
And that's why I was wrong to say that 2015, 2017 were irrelevant. The profit made in 2018 is of a different character, but not a materially different character.
Conceptually, our complaint is the same.
Yeah.
And in answer to my ladies, it's what they seek to do with the gain they say we made that goes into the profit split method is to allocate a further amount as a reward for services that were priced under the APA. The question for the court is, are they entitled to do that ultimately? So there's no doubt, common ground, that that's what they are seeking to do. Common ground, the APA does something. So the issue before the Upper Tribunal, the issue before this court is what's the effect of the APA?
And I just want to identify exactly what the vice is. There's a sort of theoretical vice, you would say, in applying two different methods to the pricing for the same services. That may mean that more, depending, it might work the other way, but that you get further tax which is referable to the provision of the same services in a later year. But that's because more money has been made from the provision of those services in a later year. So there's no question of you having to pay more money on receipts you've already had. It's only because you have had those receipts, or notion you should have had those receipts,
We've had our cost plus 10%, and we paid corporation tax on it. So
yes, but that is notionally, that is for foregone profit in a particular year. The new method is applied to foregone profit in a further year.
well, that's the different year point.
Which is what it's all about. But I'm trying to see whether there's any vice. There's nothing like double taxation here. If there was, I'm sure you would have said it by now.
I would have done, but there's
Yes,
not.
but I'm just spelling it out to myself as to what the vice is.
It's not that we're paying tax twice on the same dollar of profit.
Yeah.
The vice is that the revenue want to both change the method, brackets, which in principle they could do, but the method they want to adopt here, particular method, involves them repricing the services for which we have an agreed method.
But it was an agreed method for years which have long ago elapsed. I mean, doesn't that make all the difference?
Well, that's the question. And I'm going to say no.
Yeah. Well, thank you. That's been very helpful, and it's a helpful way to have structured it, if I may say so, that you've gone straight to, as it were, the substance of our real complaint. But now you're going to deal with it in more technical language.
Well, I am.
That's what 5 and 6 were.
5 and 6 really is. We've climbed to the battlefield now.
Yeah.
5 is let's look at the APA, and then 6 is if I'm right about the APA, what errors of law is the applicant will make. So we need to turn up the APA itself, and I need to meet my Lord's observation that, well, this is just different years, and we say, no, that's not here an answer. So this is in the supplementary bundle at tab 1. So I think I said in opening it was signed in 2013. It wasn't. It was signed in 2012. So it's November 2012, page 3, page 4. The companies in recital 1 are the same companies that are the appellants here. They've been renamed, but they're the same legal entities. It's an agreement between those companies and the revenue. So it's recital A pursuant to part 5 of TIOPA, and then TRUK is the 3 companies. TRUK and the revenue would like to enter into an advanced pricing agreement to establish an appropriate transfer pricing methodology in satisfaction of Markets UK's obligations under provisions of part 4. In relation to achieving an arm's length allocation of income and expenses for cross-border transactions between TR Markets UK and related parties. So it's a focus on particular cross-border transactions, a point I'll come back to. Recital B, the APA has a 5-year term beginning with the accounting periods of Thomson Reuters Markets UK commencing 1st January 2010, so it's 1st January 2010 to 31st December 2014, and then with a rollback period from 1st October 2008 to 31st December 2009. Now, I'm afraid we do need to look at some of the definitions. So, just reading quickly through them, advisory services, page 4, means the functions and activities undertaken in relation to the operational management of the Thomson Reuters Markets business. It involves a discrete number of providers which principally support TRGR. The provision of advisory services applicable to the years ended 31st December 10 and 11 and the rollback period. Now, the point I'll make in a number of places, some of the definitions of advisory services have a time frame in them. So advisory services, we know it's rollback and 2010 and 2011. 2 definitions down, the APA is the Advanced Pricing Agreement. Last definition on the page, content development and acquisition services. The functions and activities performed in relation to the content sets of financial, business and other types of data generated internally by Thomson Reuters Markets UK. And that definition in content development and acquisition services doesn't have any time limit. Now, just so you see where I'm going, some of the definitions are limited for particular periods, so you're only looking at that type of transaction for particular sub-periods of the whole period. Some of the services are not limited in terms of...
You say not limited. Well, I suppose it comes back to the main point. They fall within 5 years. Well,
there's no express identification in the definition of particular periods. I do want to take this carefully in stages.
No, okay.
So, top of the next page, corporate services. I shan't read all of these out, but that's not limited by time. Covered transactions means the transactions described in clause 2 of the agreement. CUP has the meaning in clause 5.2, but it's well, we'll see that when we get there. And then data hosting services, not time limited. Then there's middle of the page, distribution activity and distribution fees. And then there's references to end user components and end user components royalty. And then over the page, I don't need to read these out, but can you just note legacy assets and legacy assets royalty. And then there's a distinction drawn when we get there between a major distributor and a non-UK distributor. And they're both defined on page 6. And then between those two, market central and support services and news and editorial services are not limited by time in the definitions. Then down that page, parts 4 and 5 of TIOP are identified, and then PSM, profit split method, has the meaning ascribed to it in clause 5.1.1 of this agreement. Just pause there, although I understand the transcriber had asked whether it would be possible to have a break.
Yes. Now. But did I miss it? Oh, I see, for the transcript.
Yes.
Well, I don't mean to be hard-hearted, but the normal term we impose is that we don't ask for a break. We don't allow breaks. But if that's going to create a real difficulty, I
understand it might create a real difference. Perhaps if we might have...
very well. We will break for five minutes. But I've had this thing before with transcript, right? It's a hard work, I understand, but it's hard work for all of us.
Yes.
Okay.
My lord, I'm still on track.
You're doing well. Okay, 5 minutes. Come back at 5 past. 6 past.
Oh, yes, right, isn't it? Yes, all right. Usually. That's right. Yeah, no, I'll thanks.
Already. All rounds of food.
Thank you.
No problem. Yes,
Well, I got to the bottom of page 6 in the bundle. I just made the point that there's a definition of profit split method, PSM,
yeah.
and we need to look at clause 5.1.1. Top of page 7, software and new product development services is not time limited, whereas synergy and integration services is. So there's a reference there to particular periods.
Periods less than the full term, stated term of the agreement.
Yes, yes. In each of these cases, it's a subset,
A subset, that's what I mean.
but it's not expressed as a subset. It's just this period.
Yeah, but it's something, but in cases you juxtapose some services where there was no time limit expressed and some where there was. Where there is a time limit expressed, is it always specific years within the envelope?
Yes. Still on page 7, second hole punch, TNMM has the meaning described in clause 5.3. TPM is a transfer pricing methodology. Transfer pricing methods means the transfer pricing methods based on the OECD transfer pricing guidelines, and then TRGR. So no definition in here of chargeable period or accounting period. Page 8, clause 2, covered transactions. This is the clause that defines the services provided by TRUK to TRGR. So covered transactions for this agreement consist of transactions giving rise to legacy asset royalty, end user components royalty, distribution fees paid by Thomson Reuters Markets UK, and then 2.1.4 fees for the following services, and then they're listed. 2.1.5 fees for other group services, that's listed as corporate services. And then 2.1.6, fees for other group services. This is synergy and integration services. Clause 3 provides for legal effect. I want to come back to that. Got to come back to that. So if we just skip that for a moment. Clause 4, critical assumptions. This agreement is dependent upon the following conditions. So 4.1.1, there will be no significant changes in the terms of the nature of the business or functions undertaken by Thomson Reuters Markets UK, as would affect the economic characterisation of that business. And then 4.1.2, there will be no significant changes to government policy or regulatory requirements, including applicable laws, tax laws and tax treaties. And then 4.1.3, no natural disaster or other force majeure event. Certain critical assumptions in 4, one of which is that the underlying business remains the same. And then over the page, clause 5, this provides for transfer pricing methods. So just to make good my point, it doesn't seek to agree specific prices, nor does it seek to agree profits in pound terms. It seeks to agree methods. So 5.1.1, the profit split method will be used to determine the royalties which will be received by Thomson Reuters Markets UK from TRGR. So they do apply, for some things, a profit split method. And then 5.1.2, with regard to legacy asset royalty, TR Markets UK will receive an annual royalty in the amount set out. The same is true in 5.1.3 for end user components royalty. So one method is profit split, another method is an agreed royalty. 5.2, major distribution. The agreed method is comparable uncontrolled price method, or CUP. So you look to comparable transactions between unrelated parties. 5.3, non-UK distribution. The transactional net margin method will be used. And then 5.3.2, Thomson Reuters Markets UK will retain a targeted 2% return on sales. So that's a 2% return on sales. And then the services we're concerned with, 5.4, services. And then in 5.4, each of the services that are identified in the definitions has applied to it a TNMM method, which in each case is a cost plus a markup. So as an example, 5.4.1.2, the application of TNMM with a net cost plus profit level indicator is calculated by identifying direct and indirect costs. And then 5.4.1.3, the markup percentage for software and new product development services is 10%. And under 5.4, each of the services is the subject of an agreed cost plus a percentage. It's not always 10%. So sometimes it's 8, sometimes it's 6, sometimes it's 15. So one can run an eye down pages 12 and 13 and you'll see each of the services are priced on a cost plus a percentage basis. Page 13, 5.4.7.4, Reuters Ltd will, only for the purposes of the APA, impute additional income of £10 million sterling in relation to corporate services on an annual basis for each of the 5 years covered by the APA 2010 to 14.
Sorry, I've lost my place. Where am I?
5.4.7.4, two-thirds of the way down page 13. This is another transfer pricing method by which the parties agreed to impute additional income to Reuters Ltd. And they didn't do that for the services that are priced on a cost plus basis. So, pausing to state the obvious, anything that's...
Sorry, just one moment.
So when it came to corporate services, they just agreed a lump sum figure?
Yes.
I'm sure that's right, but let me just...
Well, it's in addition to a cost.
It's an addition, exactly.
A cost plus markup.
Exactly.
Because the cost plus markup itself is in 5473.
Yeah.
And there is an imputation of an additional amount in 5474.
So there will be well, it doesn't matter, but there will be a fee for corporate services, which will be the fee actually charged, and there will be 10 million, and then 6% will be paid on the aggregate of those two.
I'm not sure whether it's designed to be cost plus 6 plus 10 million, or cost plus 10 million plus 6, but for present purposes it probably doesn't matter.
Doesn't matter, that's how I read it, but it doesn't matter.
But the significance is that in some parts of this agreement, the parties agree a profit split.
Yeah.
In some of them, they agree a royalty. In some of them, they agree to impute income. Some of them, it's cost plus. So the thing that the revenue are now trying to do, which is to apply a profit split method in a later year, which includes allocating a proportion of the profit made in that later year as an additional reward for the services provided in 2008 to 14, in principle, could have been in this agreement. It could have been cost plus 10% plus X. Where X...
Not, sorry, it goes back, it circles back, but it keeps being my roadblock. Not if you wanted certainty in the given year.
Well, because what we're agreeing here is a methodology,
Yeah,
not a number.
I've got that point, but equally, if you just want an APA that tells you what tax you pay at the end of the year on a transfer pricing basis, you can't build in contingencies that might be 20%
but because inherent in a profit split method, you can do that, and the parties have done that for some of these services. The profit split method takes whatever profit you made
In the given year or across?
no, in a given year at some point in the future and allocates a slice to these companies pursuant to that profit split method.
Is that right? Can you take me to a profit split example here and let's see how it works out?
5.1.1. So that's a direction to apply the profit split method. And that is taking a profit of a later period and then splitting it in accordance with a method.
We apply to the profit. You'll say that's the very issue in the case, but there's nothing here that indicates it will apply to the profit of any period beyond the term of the agreement.
We are the starkest example of a profit split method being applied with retroactive effect, because
yes, but in this, which my lady asked us to, this is a case where there's been an explicit agreement for a profit split. That agreement for a profit split method will only apply up to 2014. That's when the agreement covers. But perhaps I'm missing your point.
No, well, that is right. If I'm wrong about that, I'll be corrected by those behind me. But that is my understanding. But my point is twofold: that this is an example of the parties agreeing a profit split method rather than something else. And we have other examples of things that are not cost plus.
But sorry, I know you may want to make 2 points, but so what? They did agree cost plus for the services of which we're concerned. The fact they could have agreed profit split doesn't need to be demonstrated by showing that they did for other kinds of income stream.
It's a point by way of emphasis that what we did agree was cost plus.
Yeah, okay, I've got that.
And to hark back to what's our real beef here is the revenues profit split method in 2018 takes the gain made in 2015.
Well, that we've got, but I'm not. You said you were drawing attention to 5.1.1 as an example of where you did agree profit split for two reasons. One of which you've just explained. What was the other reason? It's unfair. I mean,
I've now forgotten
right.
what the other reason was.
You could say, because my lady asked for an example.
That may be an answer. If it comes to me, I'll come back to it. But
yes.
The significance is that it wasn't beyond the wit of the parties to agree a profit split, because they did.
Okay.
Now, the ultimate point against me, and I'll come back to. Let me continue walking, and I'll come back to clause 3.
Of course.
It all turns on clause 3.
Yeah.
So, clause 7. Right, we won't walk through the whole of 5, but you've got the point. 7.2 provides that TR Markets UK remains subject to all applicable UK taxation laws not directly affected by this agreement. So we accept that. The debate is, what is the scope of the agreement? 7.6 allows this agreement to be revoked or modified. That harks back to section 225, etc. So it can be revoked by the revenue where Thomson Reuters Markets UK fails to comply with its terms and conditions, or where the critical assumptions cease to be valid. One of those critical assumptions is your business hasn't so fundamentally changed that the transfer pricing method is no longer appropriate.
Sorry, just coming back to 7.2, I mean, it's expressed in very wide terms, isn't it? It remains subject to all applicable UK taxation laws not directly affected by this agreement. Now, surely at the date of this agreement, the charge to tax in respect of diverted profits was not even a cloud on the horizon.
The glint in the eye of some chancellor.
Yes, well, it wasn't even, I mean, it was first referred to, wasn't it, in the autumn statement in 2014 or something I read somewhere.
Yeah.
But here we are back in 2012 when this agreement is signed. So, I mean, it seems in a sense statement of the obvious that this agreement is not intended in any way to have any impact upon taxation matters outside its ambit, including taxes which haven't even yet been imposed by Parliament.
Well, that, my lord, is harking back to the point the revenue no longer pursue, that it's a different tax.
Well, they may not want to pursue it, but I think I may want to, or we may want to. I mean, what's wrong with it? That is an argument.
From the Commissioner's
It's not
point,
quite what the point was,
no,
anyway,
it's-
was it?
from the
The point was that it was inherently a different tax, whereas my lord's point is more about taxes that have never even been conceived of. I didn't put that very well. I'm not sure which
one is the example of the other. So
Yes,
let me
okay,
test it
okay,
by
no,
a tax
all right.
that is not
Yeah,
conceived of.
I'll butt out of this. Let my lord
But
continue
the
his.
point, my lord, is this, that to say DPT is a different tax to corporation tax, the revenue rightly recognised proves too much, because they have accepted publicly as a matter of policy that there are some circumstances in which the charge to DPT is a charge based on an arm's length price.
That I accept, but I mean, we're still left with the words directly affected. I mean,
Yep, and I accept that. So another way of expressing the debate between the parties is, what is a tax that is directly affected by this agreement?
yes.
So clause 8 requires compliance and monitoring, so we had to produce an annual report, which we did. And had the revenue been unhappy with our annual report and our compliance, they had the statutory ability to revoke or modify the agreement, and they didn't. And then 9, this agreement, headed duration of this agreement, the agreement has a 5-year term, beginning January 2010. Additionally, a rollback period. And then the second paragraph, the revenue confirmed their willingness to consider, in accordance with the law and practice prevailing at that time, a renewal of this agreement without prejudice to the rights of either party, and to consider the appropriateness of the transfer pricing methodologies proposed in respect of the covered transactions and any other transactions as Thomson Reuters Markets UK might propose to be covered by any new APA. So that is recognition that the parties might agree to renew the transaction for a future period to address the covered transactions and possibly other things. And then clause 10, governed by English law. So, let me go back to clause 3. Absent clause 3, we know that some of the services that are covered transactions are time limited in that they have to be services provided in particular periods. But some of the services are not time limited in the definitions of the particular terms in the agreement. So at least one of the things that clause 3 has to do is to identify what services are to be covered transactions. So 3.1, page 9, this agreement is made pursuant to and for the purposes of the provisions of Part 5 of TIOPA, the APA regime, and binds the parties for the duration of the agreement. So that has to be 2008 to December 2014. To determine the treatment of the covered transactions in accordance with the terms of this agreement. So where there is otherwise nothing that identifies which transactions are covered transactions, Clause 3.1 in our submission provides that the APA applies to services provided in the periods 2008 to 14. And Clause 9 recognises that the parties might agree to renew the agreement for covered transaction services provided in later periods. So the effect of 3.1, when read with all of the definitions, is to identify services provided in which periods are covered transactions which will benefit from the agreed methodology. Clause 3.2 provides that the revenue will be bound by the terms and conditions of this agreement and will not impose during the currency of this agreement any transfer pricing adjustments to the covered transactions which might otherwise have been made pursuant to the application of provisions of Part 4 of TIOPA. So the revenue are bound during the currency of the agreement, so during 2008 to 14, they're bound to apply the APA and not the transfer pricing provisions of TIOPA, or here the DPT regime. We say as regards the services provided in 2008 to 14. So reading 3.2 and 3.1 in context, we say the provisions make clear that the agreement binds the revenue to the methods agreed in the APA for services provided in the period, those being the covered transactions, such that the APA applies to the tax treatment of those services, and TIOPA does not, whenever an issue as to the pricing of such services might arise. Pausing there and putting it at a slightly higher level of generality, this agreement could have said, this method is agreed for the purposes only of computing profits for accounting periods falling within October 2008 to December 2014. But this agreement is not expressed in terms of accounting periods or chargeable periods, it's expressed in terms of transactions. So what the parties are agreeing is the pricing methods of these transactions, services supplied in this period, irrespective of when that issue might arise.
It could have been, on your argument, it could have been much more clearly drafted, couldn't it, 3.2? Because it could have said that HMRC is bound by terms and conditions of this agreement and will not impose any transfer pricing adjustments to covered transactions made during the currency of this agreement.
It could have been, I accept that.
It could have been much clearer.
Yeah.
What it actually talks about is won't impose a different tax treatment during the currency.
Yes, well, I accept that. But there's a difficulty. My learned friend faces two difficulties. Firstly, it doesn't say expressly that this is the agreed method for pricing services provided in these chargeable periods, but only to the extent that we're interested in the computation of profits in these periods. It doesn't expressly say that, because it's not expressed in terms of chargeable periods or accounting periods, it's expressed in terms of transactions. Second difficulty you face is if you look at 3.2 literally, the revenue are bound not to impose during the currency of this agreement any transfer or pricing adjustment to the covered transactions. Well, think of the accounting period ending December 2014. Tax return for that period doesn't have to be filed until December 2015. The revenue then got a further year in which to open an inquiry, and only once they've opened an inquiry can they make a transfer pricing adjustment. So for the 2014 year, they couldn't make a transfer pricing adjustment during the currency of this agreement. So if it is read at its most literal, this agreement doesn't work for the accounting period ended December 2014. Because the return couldn't be lodged until the 1st of January 2015. So the fastest it could have been done was a return made on 1st of January 2015, the revenue open inquiry the same day, and make a transfer of pricing adjustment that same day. But that's not within the currency of the agreement. And the same is in fact highly likely to be true of 2013, because that return is not made until December 14, and the revenue got until December 15 to open an inquiry. And indeed,
well, is that? It's true the definition of the duration is in terms of the accounting period. But in the context of a tax arrangement, that necessarily implies a reference also to the tax period, tax year typically, in which that liability for that accounting period would arise.
My Lord, I think he's making a slightly different point. My point at the moment is that if you read during, they can't do something during the currency of the agreement, they wouldn't be prevented from doing it for the last year, 2014, because the adjustment can only be made in a period that's not in the currency of the agreement. But it's worse than that, because for each of the years 2008 onwards, the taxpayer has to file a return. The revenue can then inquire into that return. They have to do so within a year of the return being made. But the revenue don't have to make a transfer pricing adjustment by any particular date. Perfectly understandably, they're entitled to look at the accounts, look at the return, think about the business, think about transfer pricing methods, and then they'll later make an adjustment in relation to a year that's open. Read at its most literal, this gives no protection at all to the taxpayer, because the revenue can just wait with open years, wait for this agreement to run out, and then make an adjustment on the 1st of January 2015 for all open years.
That might be an abuse of power, Mr. Peacock.
Well, it might be, my lord, but it would be contractually open to them if my learned friend is right as to the most literal reading of this agreement. Now, I'm proceeding in stages. If we say, well, that can't be what the parties intended to agree. It's not what this APA was designed to do. So what you've got to ask, was this APA designed to agree a method to price particular transactions, or was it an agreement for a particular method to price particular transactions, but only for the computation of profits in the year covered by the agreement? We say it's the former, because that's what gives proper effect to an APA. It brings certainty to the revenue and to taxpayers. My learned friend has to say it's the latter. So ultimately, this case turns on what you think 3.1 and 3.2 mean. We say read purposively, textually, and contextually, it is quite clear that what the parties were thinking they were agreeing was methods to price particular transactions. And it is of real significance, we say, that the agreement is expressed in terms of covered transactions, not covered years or covered periods of account. parties are actually agreed that the subject matter of this agreement is the services provided between 08 and 14. They're the covered transactions. The parties are agreed that the purpose of the APA was to agree a method to price such services for the purposes of computing profits. There is no express reference in Clause 3 to the agreement being for the purposes of computing taxable profits in the accounting periods falling during the agreement. The revenue say you've got to get that from 3.1 and 3.2. We say no, 3.1 and 3.2 are doing two things. They are providing a time limit to identify covered transactions where their time limit doesn't appear in the definition. And it is making clear that the revenue are bound by the agreed methods for these services provided in these periods, irrespective of when that question might arise. And one gets a final sense of that from 3.3. For the avoidance of doubt, nothing in this agreement shall, in relation to years covered by this agreement, prevent HMRC from raising a transfer pricing inquiry in respect of any transaction entered into by TR Markets UK, which is not a covered transaction. Again, it's expressed in terms of transaction. The effect of that, we say, is that TR UK had vested or accrued contractual rights to have these covered transactions priced on a cost-plus basis, whether the revenue attempts to apply a different profit split method in an accounting period in 2008-14 or later. If what you're trying to do is reprice these services in these periods, you are barred by this agreement. We say that's the deal the parties did, and that's the deal the parties should both be on. And one can test that by imagining a simpler example where we'd agreed cost plus 10% for these services. The revenue in a later year said, well, we think it ought to have been cost plus 20. Taxpayers are entitled to say, well, no, look at the terms of the agreement, that's what you agreed. And this issue wouldn't have arisen if this IP had been sold on the 31st of December 2014. Only because it was sold, it turns out, in 2018, that this issue arises, but it's the happenstance of the date of sale that allows the revenue to run this argument. And it also actually requires TR UK still to be providing services to TRGR in 2018, because if they weren't, again, this issue wouldn't arise. So we say properly construed, that is the effect of this agreement, and therefore 2018 is a year to which the APA relates, since it is a year in which the revenue are seeking to reprice the covered transactions, being the services provided in 2008-14. And that accrued or vested contractual right under the APA to have the covered transactions priced in accordance with the agreement did not simply evaporate midnight on the 31st of December 2014. The Commissioner's case has to be, well, that right was vested, was a good legal right at a minute to midnight, and a minute after midnight it's gone. Again,
I mean, that's the nature of any time limited.
right. One has to, my Lord, I quite accept that, but one has to ask, is that what the parties were agreeing?
Yeah.
And we say no. That doesn't give effect to the overriding need for certainty. Now that would allow me to turn to my last heading, which is the Upper Tribunal and what we say are the errors of law. And so that's in the core bundle, tab 6. And there's a lot in here that we for obvious reasons, we don't quibble with. So, para 22, the Upper Tribunal rightly identifies the purpose of APAs. Para 30, the Upper Tribunal are right about the interrelationship here of DPT and transfer pricing. Para 33, they're right about the public law principles. And para 54, perhaps just to note that. It is sufficient to note the revenue accepted that some of the DPT charge in 2018 was referable to the services provided between 2008 and 2014. So it's referable to, at least. And how that arose, you can see in the exchange between the revenue and my instructing solicitors in 55 and 56. And 56 records that the revenue's thesis here is that they can allocate an element of the profit or the gain made in 2018 to the services provided in 2008 to 14. So having identified that this is a narrow question, if I invite the court to turn on to 66. The court here tackles relates to first. My respect is perhaps easier to start with the APA, but I'll do it in the order they dealt it. So they addressed the statutory question of relates to first. And they had the benefit of an authority, Veolia, that was cited by Mr. Ghosh, which establishes that relates to is either broad or narrow depending on its context. It's in the bundle, I'm not sure you need to see it. It's not a surprising proposition. And then there was a little bit of a debate about what the court had said in Veolia. But picking that up at 74, and what I'm going to enumerate is what I say are the errors. So 74, statutory scheme is one whereby agreements entered into between the tax authority and the taxpayer are given statutory force as an exception to the statutory provisions that would otherwise apply. Well, I don't accept that formulation, but they then say as a starting observation that might well suggest erring on the side of an interpretation that is less expansive rather than more. And we say, well, no, that's a starting error, error number one. The statutory regime provides for arm's length pricing to be identified for connected company transactions. The statute provides for APAs by which the parties might agree such an arm's length price. It's not an exception from a general statutory rule that ought to justify a narrow reading. It is simply a means of agreeing that which the statute requires, which is an arm's length price. So you can't start from the proposition that it's an exception to some general rule that justifies a narrow reading.
That's not really the point they're getting at here, is it? 74. They're looking at the public law context and saying that where you have a statutory provision that potentially disapplies, that potentially prioritises an agreement over what the statute might otherwise require to be collected by way of tax, that your starting position should say that you shouldn't construe that any more broadly than you really need to. Because that's quite a, to my eye anyway, section 220 is quite a startling, it's quite an interesting piece of legislation.
Constitutionally a rather interesting provision.
And it does the thing that we talk about a lot in public law tax work, which is can you stop the commissioners from collecting tax that's due under the statute because they've made an agreement or given a representation that they won't collect it.
But what they're saying here is it's a starting observation as to the scope of relates to. So they're making a statutory construction point, not a public law point.
Yeah, but the statutory construction needs, I mean, it is, the two are the same, or at least they connect.
But can I quibble with your ladyship's suggestion that this is somehow an exception from a general rule? It's an agreed method of arriving at that which the statute requires.
Yes, I think I'm quibbling with you, Mr. Peacock, and saying it's not this. They're not addressing here the methodology point. They're saying you have to look at where the section sits in the wider context.
I quite accept that.
Point.
But the reason I pick that up is 75 begins accordingly. So I say their starting point I don't accept in 74. 75 begins accordingly. In contrast to the way related to was used in the relevant legislation in Veolia, there is no difficulty with understanding that term as meaning section 220 will only apply to chargeable periods to which the APA says it applies. Well, there are two problems with that. Their starting point is some said to be justified narrow approach we don't accept. But then there's no logical link between taking a narrow approach to relates to a conclusion that the APA only agrees to the chargeable periods to which the APA says it applies. And then the other problem with that is, well, it just begs the question of what periods to which the APA says it applies. So they're starting from an assumption that the APA only has effect to compute profits as regards these covered transactions for chargeable periods that fall within the duration of the APA. And I say that's wrong. So that's error 2. And they're just reading on in 75. That way, the suspension of the statutory provisions that might otherwise apply will keep in step with what the parties have specified. Well, that seems to suggest that a narrow approach to relates to allows the court to conclude that what the parties have agreed to is somehow aligned with the statutory code. But that's true if I'm right. What we're really arguing about is who's right, and either of us say we align the APA with the statutory code, but it isn't as if one conclusion, one construction rather than another tells you that you're aligned with the statutory code. It doesn't say that. So we don't accept 75, I think that's error 3. And still in 75, but at the foot of that page, they say, well, in effect, if the taxpayer is right, rather than respecting a bright line between what is covered by the agreement under Part 5 and what is not, and therefore under Part 4, it would open up more scope for argument. Our analysis equally gives rise to a bright line between the statutory regime and the APA. We just disagree about what that bright line is. So it isn't as if one can say, well, drawing a line in one place rather than another necessarily opens up more scope for debate. So we say that's error 4. And then still in 75, the working thesis here, we acknowledge the legislation does not use the term specified in or covered by, but that concept of relating to is capable, the concept of relating to is capable of different degrees of breadth, and we consider the context in which the words to which an APA relates appears here is consistent with the more constrained interpretation we have suggested. But that is in effect a conclusion that you read the APA as only having effect for the computational profits for chargeable periods falling within the term of the APA. That's to beg the very question they're trying to answer. It's not itself a reason to that answer. So that's error 5. Para 76 relates to an argument that was had below as to whether we learnt anything from the scope of section 224 and the ability to go backwards as well as forwards. So what the Upper Tribunal are saying here is the chargeable period to which the APA relates requires identification of the chargeable periods to which the APA is intended to have effect. We agree with that. That just restates the debate. It doesn't answer it. So we say there's nothing in 76 that drives the answer the Upper Tribunal ultimately arrive at, and their belief that it does, we say, is error 6. And in particular, in para 76, they say, well, the APA can have a rollback period under 224 that is otherwise forward-looking. And the UT say, well, that tells us that APAs cannot extend to future periods which are not specified in the APA. Again, that's really just to restate the problem, because what you're interested in is which periods computation of the profits for which are governed by the treatment of these transactions under the APA. But to say that the agreements can be forward-looking doesn't tell us the answer to our problem. So that's error 7. Upper Tribunal para 77 they reject Mr. Ghosh's argument that the necessary relationship under 220 is satisfied by any sort of connection between the relevant chargeable period and the APA. I'm not certain that was Mr. Ghosh's case, but it's not what we say here. We do not say that any connection is enough between the covered transactions being the services of 08 to 14 and the DPT charge in 18. But we do say it's enough for Section 220 statutory protection if the revenue seek in 2018 to reprice the very services they agreed a cost-plus method for in the APA. So that paragraph misstates the real position, we say constitutes error 8. Now, all of this strictly is just a run-up to the key part of the Upper Tribunal's decision, which relates to the scope of the APA. And for reasons I've already outlined, we think the better way of approaching this is to look at the scope of the APA, and that will then tell you the relates to question, the answer to the relates to question, rather than the other way around. But from 78 onwards, to which chargeable periods does the APA relate? Mr. Ghosh made submissions about the effect of 3.2, that's in para 79. He made the point that some of the definitions of covered transactions had no time limit and you needed clauses 3.1 and 3.2 to address that, and I've made that submission again. And that's rejected by the Upper Tribunal, so 79 and 80. It's rejected by the Upper Tribunal at 81. We need to see why it was rejected, but they accept, second sentence of 81, a crucial step, as Mr. Bremner pointed out, has been overlooked. That is that the arm's length pricing of the services as set out in the APA can only be relevant as a matter of law under Section 220 once it's established that the APA relates to the 2018 chargeable period. To rely on the pricing of services in the APA as the means by which the necessary relationship is established is a bootstrapped argument. The APA cost-plus pricing would only ever become relevant once the relationship is already established. That's the pricing of the services in the APA, that's the reference to it. It cannot be the means by which the relationship is established. So what was said against Mr. Ghosh was that he was relying on a bootstraps argument. In our respectful position, that's not the case at all. The Commissioner's stance here is that their profit split method in 2018 is good in law, even though it allocates a part of the profit of 2018 as an additional reward for the services provided in 08 to 14. So if you're asking the question of whether the chargeable period 2018 is a period to which the APA relates, it is highly relevant, and indeed we say conclusive, that what the revenue are trying to do in 2018 is to reprice the services of 08 to 14. Putting that point another way, 2018 would not be a year to which the APA relates if the revenue were not attempting to attribute the profits to TRUK by reference to these covered transactions. Because they are doing that, then 2018 is a year to which the APA relates. The Upper Tribunal were wrong to describe that as a bootstraps argument. It's not. It's the very link that the commissioners are asserting. 82 we say is wrong for the same reason, and 83 is wrong for the same reason, because there they reject further arguments that Mr. Ghosh had advanced. But they reject them on the basis that because 2018 is a different year to 2008 to 14, that is somehow enough. We say that's not right. So that is error number 9.
All your errors, perfect good forensic technique, but they all really come back to the same point.
My lord, they do. I've got 11 we've been walking through, but they are all in effect the same point.
You may not expect to find each of your 11 errors religiously examined in our eventual judgments.
But the the
Anyway,
point-
but
you-
I see what you're doing. You're pointing to various ways in their reasoning where the fundamental point kicks in.
Yes, and we say they've either misunderstood it or misdescribed the issue, or if not misdescribed it, then they've answered it, we say, wrongly. Perhaps if I just quickly pick up, in 84, Mr. Goshen made the point that the 2018 profit calculation rests on provisions, so you've got to look to transactions. And the Upper Tribunal say, well, that's true, but you've still got to compute profits for a period. Well, again, we accept that. That's not an answer to our complaint here, that even if you're computing profits for 18, if what you're trying to do is reprice 08 to 14, we say it offends the APA. And then under, perhaps I don't need to walk through, but if the court will accept from me that we have the same underlying complaint about paragraphs 86 through to 90, under the next heading, other arguments, they reject a whole series of other arguments, but we say in effect with the same underlying flaw. There's one point the court should know, paragraph 92, Mr. Ghosh pointed out, the Revenue has made a corporation tax amendment on the same basis, i.e. using the profit split method which is applied in part or is referable to services provided earlier in 08 to 14, then that would equally be, it says permissible. We think that's a typo for impermissible.
Yes.
I think they ought to be rejecting the argument for the same reasons.
Thank you. Yeah.
But we say the other arguments that were advanced were in law good ones, and the Upper Tribunal were wrong to reject them. So if we stand back, the Revenue agreed a cost-plus method to price the services in 08 to 14. There was no reason to revoke or cancel the APA, no reason to revisit it. The Revenue then decided in 2018 to apply a profit split method and allocate a profit share to TR UK for past services. We have no public law complaint to the extent that that allocation increases the price for services provided in 15 to 18. The public law complaint is that it goes further than that and allocates an additional element of services provided in 08 to 14. And that, we say, offends the APA read properly, textually, purposively, contextually. So those
Very
are
elegantly timed.
my submissions. I now hold out in terrorem to the court that you can hear from Mr. Grzinski on public
Well,
law.
we've given that some thought in the break helpfully provided by the shorthand writer. I think our view is we, not at the moment, or at least I am not at the moment persuaded that this is really central to Mr. Brinsmead Stocker's argument, and he is, see, his body language suggests I may be right about that. And I think it would make more sense to wait and see the extent to which and how it is developed in his submissions, and then we can see either Mr. Grzinski may not be necessary at all, or if he is, he will only be necessary on less than might appear from reading the skeleton argument. It's a very long-winded way of saying, let's wait and see how Mr. Brinsmead Stocker puts it. Everyone seems happy with that, because that is the issue on which he was going to be addressing us, isn't it? Yes. Well, a very, as I say, very elegantly timed. Knowing that I have to rise at 4:15, and even knowing that with Mr. Brinsmead Stocker, sorry, Mr. Grzinski may have a few minutes at the end of you, quite apart from any reply from Mr. Peacock. Do you still think we're on time, Mr. Brinsmead Stocker?
My lord, I will do everything I can to finish by 4:15. I can't
Well,
guarantee.
no, to allow us to finish by 4:15.
Well, indeed.
It's you finishing by.
Sorry.
No, and we're not asking for any guarantees. It is listed for a day and a half, but frankly, it's been very efficiently put forward. There's a lot you won't have to go back over. So we are hopeful that you will be sitting down significantly before 4.
As am I, my lord.
But, so it depends on us.
I will endeavour to be
Very
as
well.
efficient as I can.